2025. This is HOA Today. HOA Today is brought to you by Zayuk Smart Properties System. Zayuk is a software and inspection service that provides you infrastructure to maintain the information of your property, whether that be payments, invoices, as well as the visualization surveys of your buildings, of your property, your landscaping, various assets that your community may own. Zayuk is specially built for HOAs and condos associations. We have voting infrastructure, we have work orders, collection systems, request for proposal systems, as well as a ledger system, and that is a way to maintain the history of your property through various points such as contracts, work orders, as we mentioned, and invoices. So in HOA Today, we go through current events in the HOA world. And we'll start with CBS News Sacramento. Diablo Grande community in Stanislaus County attempts to recall HOA board. Small western Stanislaus County of community of Diablo Grande recall their homeowner association board, prioritized cosmetic fines over a looming water crisis. Their monthly bills spike. Keep water flowing. Kern County Water Agency extends deliveries until December 31st after the Western Hills Water District committed to payments on its $13 million debt. Uncertainty whether water will continue past January. And they believe, the homeowners, that the energy of the board is being allocated somewhere it shouldn't be, such as lawns and fining for those lawns rather than worrying about the issue with the water agency. Conservation makes it hard to maintain grass while staying under tiered water allotment. One resident's water bill was $543. Residents delivered a recall petition after what Antigua described as dismissive treatment by the board. Claimed the recall will require 717 votes, including vacant lots. 51% of property owners must support the effort. This is by East Idaho News. Recent changes in HOA law by Forrest Fisher, Moulton Law Office. Idaho legislature several years ago set its sight on the laws regarding homeowners associations. One significant catalyst was HOA's increasing popularity of short-term rentals through services such as Airbnb and Vrbo. Airbnb and Vrbo are not very welcome within HOAs throughout the world, I would guess. HOAs are specific to the United States, but those types of decentralized asset ownership systems are universally needed. And in that sense, many HOAs are built for residents or long-term renters or owners or long-term renters, and many HOAs have limits on the lowest amount of time a resident can rent, often 30 days. And it's interesting to see that being listed here as a catalyst for Idaho, which makes sense because in the United States, if you look at the population increases and decreases over the last 3 or 5 years, those mountain states, I believe Wyoming, Idaho, and Montana specifically have increased in population. I believe they had a huge migration into those areas in the last 5 years. So it makes sense that because not, I believe those places are also heavily traveled through. And so when you bring Airbnbs and more residents, it many issues converge into something like this. Following an Idaho Supreme Court decision in 2022, the legislature collected the various statutes regarding HOAs and recodified them into a single body, the Homeowners Association Act, Idaho Code Title 55, Chapter 32. This particular attorney has experienced an influx of clients requesting help and legal representation regarding their HOAs. Idaho's HOA laws were sparse until very recently, but that is now changing. An influx of transplants who tend to rely heavily upon HOAs for administering the rules make it essential for you to be aware of your rights as a homeowner within a subdivision governed by CCRs. And this article highlights two major issues: short-term rentals and due process hearing for violations. And many people are looking to amend CCRs to limit or prohibit STRs, short-term rentals. Idaho Code 553211 prohibits HOAs from amending, adding, or enforcing any covenant that limits or precludes short-term rentals unless expressly agreed to in writing by the owner of the affected property. And then this is what that means. Quote, HOAs now effectively need 100% owner approval to limit or prohibit short-term rentals, unquote. And the second most common question pertains to alleged violations of the CCRs. Prior to the act, HOAs could fine homeowners for violations of CCRs. However, the act turned this practice on its head with the passage of Idaho Code Section 553206. Before an HOA can fine a member for violation of the CCRs, two things must occur. First, the covenants need to expressly state that the HOA has the authority to impose fines for violations. Without this, the ability to assess fines is dead on arrival. Second, if the authority to assess fines exists, the HOA must hold a meeting or hearing to determine whether there are grounds to impose a fine. The HOA must give at least 30 days written notice before holding the hearing. What constitutes, if an HOA fails to satisfy both of these elements outlined above, it cannot issue a fine to a member. Ultimately, HOA law is a perfect blend of two of my preferred areas of practice: business law and real property law. On one hand, an individual's property rights are constitutionally protected. On the other hand, when you buy a home in a subdivision, you expressly join a corporate organization and agree to abide by certain contractual provisions that affect your otherwise free use of your property. And I'm not a lawyer, and nothing I say is ever legal advice, and I have never given legal advice, and you should always refer to lawyers especially in HOA Today, we speak about HOA Today, so lawyers with experience in HOA law. And here in California, that's very easy to find. I'm sure in states like Florida, that's also easy to find. Maybe in states like Idaho, that could be a bit more difficult, but they're out there. I mean, and they're writing articles like Forrest Fisher of Molten Law Office. And it's interesting to consider that this is one of many states that are increasing the legislation around HOAs. And as he mentioned, I'll just read it again, quote, "On the one hand, an individual's property rights are constitutionally protected. On the other hand, when you buy a home in a subdivision, you expressly join a corporate organization and agree to abide by certain contractual provisions that affect your otherwise free use of your property." And this is one of the pillars that I always speak about that people should heavily consider is the governance of your association, of your property. And so the three pillars I speak about are asset hygiene, financial hygiene, and governance. If you can understand those three aspects of the property, you'll know for sure how whether or not you're looking to purchase. And many people don't consider the last two that I mentioned, which are financial hygiene and governance. And most people consider that that's their personal property and they have rights to their personal property. And through asset hygiene, most people are able to determine whether the curb appeal is there, whether the landscaping is nice or is degraded, whether the structure, the painting, the asphalt, the sidewalks are level. Various things seem as though the property is being maintained well or not. That's asset hygiene. That's fairly easy to interpret. The second one that's less easy to interpret is financial hygiene. What have been the state of the finances over the last 3 to 5 years? How have the budgets increased? How have the assessments increased? Have there been any special assessments within the last 3 to 5 years? What were those put to? Now you check the reserve study. How much have the reserves been filled over the last 3 to 5 years? How are the reserves looking over the next 3 to 5 years? Are there any projected special assessments in the 3 to 5 years upcoming due to any asset degradation needs, any roofing, electrical work, balconies, foundational work, asphalting? Do these need to be switched out within the next 5 to 10 years? And is this property amply funded for that? That's not easy to interpret, and most people don't look into that deeply enough because they don't understand. I don't want to say they don't understand, but many people do not respect that this is a business that they're purchasing into. It's not just their own property. And with that comes it's a business. It needs to run effectively. Most people purchase real estate as a store of value as well as a place to live. They like to feel like they own where they live, but they're also hoping that that real estate is a store of value that will appreciate and down the line will be worth more than it is today. And within HOAs, it's important to consider that because although there are more macro level macroeconomic factors into whether your real estate will appreciate in whatever time frame you're looking at, whether or not you have to change your association will still affect the amount of finances that you have to pay. And especially like a state like Florida, where the buildings are now getting to end of life, there wasn't great maintenance. It's affecting the insurance rates, which is affecting the HOA. rates, which is affecting the homeowner's ability to live there comfortably, it becomes a much bigger issue. And Florida is a very unique case, it seems like. It seems like it's the most extreme case. And that has to do with one, the amount of people and the amount of condos and HOAs there. Two, the weather, salty wind with the hurricanes, extreme weather patterns in the last several years. It leads to this. And then also some policy that may have been that had to have other policy to counteract it, because it was actually making the situation more extreme for homeowners in Florida. But that is one case where if your HOA had been amply funded for the 3 or 4 decades prior to your purchase, you likely wouldn't have been affected as much, where other properties had not been funded appropriately, were not maintaining the property appropriately, and there were these calls for massive amounts of assessments to meet the requirements set out by the government. All right, we'll continue. This is by Non-Doc. Quote, 5 exhausting years HOA dispute over short-term rental could hit Oklahoma Supreme Court. 2019 spat over short-term rentals. It's interesting to consider how long ago that was. That's 6 years ago. In Northwest Oklahoma City neighborhood escalated from email arguments to a homeowner's bankruptcy. Twice appealed lawsuit climbing toward potential review by Oklahoma Supreme Court. Individual bought a house in Silverhawk neighborhood in 2015, contacted HOA before using it as a short-term rental in 2019. He rented it through Airbnb and Vrbo. Soon, he received notice from leaders that placing his house on HomeShare Market violated the covenant, even though it didn't mention short-term rental arrangements. Both parties held their ground. Case went to bench trial in January 2024, ruling in the HOA's favor. Eventually, the association filed a lawsuit against Tawaz, the individual, arguing the renting his home violated the neighborhood's restriction. Silver Lake appealed. Oh, give me one moment. The individual appealed the ruling. In July, an Oklahoma Court of Civil Appeals overturned the decision in a 2-1 ruling, finding the HOA's covenant ambiguous and that the use of property as a short-term rental cannot constitute a nuisance or violate the declaration in and of itself. That's interesting. That's really interesting. And now Silverhawk HOA has appealed the decision. And this individual had to file for bankruptcy. Miscommunication sparked multi-year litigation. Stinson awarded the Silverhawk HOA legal fees and court costs totaling $152,000, combined with an assessed HOA fine of $8,300. Forced him to file for bankruptcy and put a lien on his home. Wow. Saga began 6 years ago to offer his home as a short-term rental. Wow. This article goes on for a long time, and I probably won't read it. Okay, we'll continue. Map shows 10 states with highest HOA fees. Okay. And it seems like it's Hawaii, California, Minnesota, New York, Massachusetts, New Hampshire, all of the ones in the Northeast, New York, New Jersey, I believe Washington, D.C. Yeah. Most of these are New England, actually. New England and D.C., Minnesota. It's interesting to consider Minnesota has one of the highest, whereas Wisconsin and the Dakotas have one of the lowest density of HOAs. A recently published book, Bad HOA, The Homeowner's Guide to War and Reclaiming Your Power, can keep you from pulling your hair out if you wind up with a bad HOA board. Prioritize property values, almost like a government agency. Act as an enforcement arm of the governing agreement. Appreciate having a safety net. Uniform rules. Who's not well suited. They don't want constraints. They intend to run a business out of their house. They see an HOA board as a big brother. Bad HOA, let readers know what bad HOA, okay. Bad HOA members disregard state laws governing a board's activity, attempt to personally benefit from their decisions, ignore their fiduciary obligations, and set rules that amplify their power. Great board members take their obligations seriously, understand and follow governing documents, acquire a good grasp or their state's HOA laws. Keep emotions out of it. Homeowners have power. That's interesting. This is from BVI News. Justice Junior Minister for Culture and Tourism pushed back against key recommendation from CRC that all hearings and meetings should be held in public for House of Assembly. Oh, this is not HOA. This is a House of Assembly. Okay, this is from the Las Vegas Review Journal. Meeting notices must state the time and place of the meeting and include a copy of the agenda with the notification of the owner's right to have a copy. Notice of an executive board meeting can be published in a newsletter or similar publication circulated to each unit owner. State time and place, including a copy of the agenda or the date on which location where copies of the agenda may be conveniently obtained. If the executive board holds a meeting limited exclusively to discussing a violation of the governing documents, including the failure to pay an assessment or the alleged failure of an owner to adhere to construction schedule, the association is required to give notice of the meeting only to a person who may be subject to a hearing. An emergency is defined as any occurrence that could not have been reasonably foreseen. Meeting for ratification of the budget. Association shall provide written notice to each unit's owner of a meeting at which an assessment for a capital improvement is to be considered. All right. Thank you, everyone. Hopefully, you're all having a great week and hopefully, everyone is taking care. But thank you for staying with us today. And this episode was brought to you by Zayuk. If you have an HOA, if you have an issue with your property, if you need a system that will help you as a manager or as a resident to maintain the information of your properties, please consider reaching out to us. We have multiple different modules available specifically for homeowners associations. Thank you